You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 88, Patent Licensing. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. In this episode, I'm going to talk about patent licensing. Remember, the whole purpose of having a patent is to have exclusive rights. That means that you have the right to exclude someone from making or using your invention. So if someone wants to make your invention, they have to get permission from you to do it. And there are basically two ways for you to give permission to someone to make your invention. You can assign it or you can license it. I talked about assignments before. An assignment is when you sell your patent. If I were to make a real property analogy, this is like if you own your home, then you decide to sell your home to someone else. The other way is to give permission is to license it. This is analogous to you renting out your home. You're still the owner, but you're giving someone else the right to live in it. So they don't have all the rights, they just have some rights to it, and that's what a license does. Licenses can be structured in a lot of different ways, but two ways you'll see that licenses are made are exclusive licenses and non-exclusive licenses. An exclusive license is when you as the owner allow someone to make and use your invention, and as part of the deal you make with the licensee, you agree that you're not going to license it to anyone else. The other is a non-exclusive license. This is when you grant a license to someone, but there's no restriction about you licensing it to someone else as well. You can imagine that if you want a license to make and use someone else's invention, you're going to want an exclusive license because you don't want other people competing with you. But if you're the patent owner, you probably, want to not sign an exclusive license agreement. You're going to want to license your patent to a lot of different people to make money from your license from a lot of different parties. So you can see what's more valuable to the person who wants a license. It's more valuable to get an exclusive license, and you'll probably have to pay more money to get that license, such as pay a higher royalty for the items that you sell. If you enter a non-exclusive license, you can probably get it for a lower amount of money because it's just not as valuable to get a license for a patent if other people are going to be able to get the same license and you're going to have to compete with them. Think about it this way. If you rented a house from someone, so you're the licensee, would you pay higher or a lower rent if the owner told you, yeah, I have the right to rent this to other people too, so maybe there'll be some extra people living in your house? If the owner said that to you, you might say, forget it, I don't want to rent it. Or you may say, okay, if you're going to do that, I don't want to pay $1,000 a month. I'll only pay $500 a month because it's worth more to me if I know that I can live in my house by myself. Sometimes you can have some kind of hybrid agreement where maybe you give one company an exclusive license in the western United States, but you give an exclusive license to another company in the eastern part of the United States. I can't go into all the different things that can go into a license, but it will probably have things such as how long the license is good for, how much the licensee will pay, whether it's a flat fee up front, whether you have to pay 10% royalties on the profits of every sale to the patent owner. It might have something like every year, no matter how many items you sell, you will owe the patent owner $50,000 or some other amount that's agreed upon. There might be clauses in the agreement about whether the licensee is able to sublicense the invention to anyone. In theory, you could license your patent for free. Tesla did this. This is basically the same thing as just telling the world that you're not going to enforce your patent rights. It's up to you whether you want to enforce your patent rights. If you don't want to sue anyone for patent infringement, that's totally up to the owner. You can have cross-licensing deals. Let's say you have one patent and someone else has another patent, but the ideal product combines those two technologies together. So both you and this other person enter into a cross-licensing deal where you grant them the right to use your patent and they grant you the right to use their patent. There are all kinds of considerations when drafting licensing agreements. If the product harms someone, who's going to be liable for the harm that the patented product did? Who's going to get the rights to any improvements on the patent? Who's going to pay for continued patent prosecution? Such as maybe the patent is still pending and hasn't issued yet, but you entered into a licensing agreement, and let's say that it's still going to cost a lot of money to get that patent issued. Who's going to be footing the bill for that licensing term? There are all sorts of other issues that can come up in licensing, but that's the basics of it. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.